My name is Hazim Ashraf, and today we will be critically analysing how the doctrine of forum non-convenience has been developed by English courts. I will be presenting the origins of the doctrine, followed by Jung-eun and Sasvin, who shall be analysing the doctrine in the present. Last but not least, Eun-chi and Zishin will be discussing the future developments and recommendations. The doctrine of forum non-convenience refers to the discretionary power of a court to decline jurisdiction when convenience of the parties and the ends of justice would be better served if the action were brought and tried elsewhere. The plea originated in the more austere climate of the 18th century in Scotland. Two Scottish cases in the 1860s recognized and applied this doctrine. However, the law on this subject can be said to have had its origin from the English case of St. Paris and South American stores, and here the Court of Appeal held that the English courts had jurisdiction. The principle laid down were as follows. Firstly, a balance of convenience is not a sufficient ground for depriving a plaintiff of the advantages of prosecuting his action in English court if it is otherwise properly brought. Secondly, in order to justify, two conditions must be met. Firstly, the defendant must satisfy that the continuance of the action would work as an injustice because it would be oppressive or vexatious to him, or it would be an abuse to the process of the court in some or other way. Secondly, the stay must not cause an injustice to the plaintiff. Such requirements were said to be difficult to prove, and the stay of proceeding was not as easily granted as seen in the case of Maritime and Brexit. Until 1974, English courts in principle respected the right of a plaintiff to choose a forum which suited him best. Furthermore, in 1973, the rigidity of these principles were modified in English court, as in the case of Atlantic Star, when granting a stay, the House of Lords considered the principles set by Lord Justice Scott in the case of St. Paris were valid, but the criteria of oppression and vexation should be interpreted liberally. Regardless, the House of Lords refused to introduce English law to Scott's doctrine. Following this, in 1984, in the case of Aberdeen Denver, the House of Lords discovered that in relation to pending or prospective litigation in foreign jurisdictions, judicial chauvinism had been replaced by judicial comity. Where the foreign court was the natural and appropriate forum, the plaintiff had to establish by covenant evidence that there was some personal or judicial advantage in English action of such importance that it would be unjust to deprive of him. Now, with the origins being laid out, I will now pass on to my teammate Jung-eun to continue on the development of the doctrine.
Thank you, Ashraf. Following the discussion earlier, the doctrine of forum non-convenience is slowly being accepted by England since the case of Aberdeen Devil. It is submitted that although this doctrine is broad in nature, but the scope of the doctrine is not unlimited because the case of Spiliada Maritime Corporations and Cansulex Limited has established two tests to be accessed for a stay to be granted on the ground of forum non-convenience. The first test is the availability of forum, whereas the second test is the interest of all parties and the ends of justice are met. The principles set out in Spiliada have been cited with approval and developed in later cases, and most recently in the Supreme Court case of VTB Capital Public Limited Company and Nutritech International Corporations and others. By looking at the first limb itself might not sufficiently overcome the problem of forum shopping, as the courts are allowed to take into consideration various factors to deal with the issue of available forum. These factors included but not limited to the applicable law, the convenience of witnesses, and public policy. Therefore, the second limb, where the best interest of justice must be met, is significant in allowing a grant of stay while controlling the issue of forum shopping. However, it is argued that the second limb of the Spiliada test seems to afford too much discretion to the courts because the English courts will need to consider various evidence about access to the remedy in territorial state to decide whether the ends of justice are met. For example, in the case of Connolly and RTZ, the House of Lords held that, generally, if a more appropriate forum has been identified, the stay would not be refused simply because the plaintiff would not have financial assistance available for him overseas. However, exceptionally, The availability of financial assistance could be a relevant factor if the plaintiff could show that substantial justice would not be done if he had to proceed in a forum where no assistance was available to him. This shows that a significant amount of discretion is afforded to the court in deciding what precisely justice is, which could possibly lead to uncertainties in its application. Also, the threshold which the claimants must surmount is very high, justified on the basis of comity and equality of states. As a result, this can pose a problems for the courts in exhausting all factors while deciding on the most appropriate forum. Therefore, it is clear from Spiliada and later cases that the exercise of the discretion is a matter for the trial judge, and appeals should be rare, and the appellate court should be slow to interfere. I will now pass it on to my teammate, Saswin, to continue on the discussion. Thank you.
Thank you, Yong-eun and Shashwin Rajan. The case of Owusu and Jackson and other before the European Court of Justice was concerned with the relationship between Article 2 of the Brussels Convention and the scope of forum non-convenient within the European Committee. The ECJ held that Brussels Convention precludes a court of contracting state from declining the jurisdiction conferred on it by the Article 2 of the Convention on the ground that a court of non-contracting state would be more appropriate forum for the trial of action even if the jurisdiction of no contracting other state is in issue or the proceeding have no connection factor to any other contracting state. The Brussels Convention limit forum non-convenient because of this case, stating that forum non-convenient is not applicable when Brussels regulation applies. The Owusu decision will have a significant impact on the determination of jurisdiction question whether claimant sue both in English domicile defendant and foreign domicile defendant from a non-contracting state in the same proceeding. In a journal article, it has stated that while forum non-convenient is not explicitly referred to in either the Brussels regulation or the recast regulation, it is generally accepted that following the decision of European Court of Justice in the case of Owusu and Jackson, whether the effect is that the English court can not longer apply doctrine where the Brussels regulation applies. Furthermore, there are limitations on the doctrine imposed by several conventions. For example, the Hague Convention has express prohibition on the forum non-convenient as seen in Article 5 sub 2, whereby it stated that there is no room for forum non-convenient doctrine to apply if there is a valid choice of court agreement between the parties. The main exception for this rule to apply is when both courts found that the choice of court agreement is null and void. Also, another limitation is on the doctrine is imposed by the Lugano Convention. It has the similar effect to the Brussels I Convention. It primarily effect toward the doctrine is in Article 23 of the Lugano Convention, whereby it provides that the parties domiciled in a state bound by the Lugano Convention agree to have a court to contain jurisdiction, the court may have that jurisdiction. This means that in such situation, the forum non-convenient will be not applicable as well. Nevertheless, an English Act, Civil Jurisdiction and Judgment Act 1982 has allowed that doctrine of forum non-convenient to be applied in the situation where convention mentioned earlier are not applicable. This shows that the doctrine is only inapplicable where there is a valid jurisdictional clause between the parties. There is no total prohibition in the application of doctrine despite several limitations. I will now pass on to my teammate Eunchi to start discussing the future of development of the doctrine. Thank you.
Thank you, Saswin. Hi, I'm Eunchi and I'll be talking about the future development of the doctrine. For future development, the post-Brexit position has to be analysed. Brexit, which means the UK's withdrawal from European Union, will have a large impact on the future application of the doctrine. This is because before Brexit, as mentioned, the application of the doctrine is severely limited by international treaties and ECJ rulings such as the Brussels I Convention, Owusu and Jackson Decision, Hague Convention, and also the Lugano Convention. Therefore, since Brexit occurred, there is uncertainty on whether the rulings of the European Court of Justice would remain applicable post-Brexit. It is arguable that the ECJ's rulings are no longer binding on the English courts, as Boris Johnson and Theresa May has unequivocally declared their intention to leave the ECJ's jurisdiction. Consequently, English courts are no longer precluded from utilizing the doctrine of forum non-conveniens due to the restrictions imposed in the Owusu case. There were several indications that the UK is leaving the ECJ's jurisdiction. For example, the UK government has released a guidance document which suggests that the government would repeal existing civil judicial cooperation rules and revert to domestic law. It also expressly mentioned that the Brussels I regulation will no longer be applicable in the UK. As the limitation on the doctrine is most likely removed in the UK due to Brexit, the doctrine of forum non-conveniens will follow the domestic law rules instead of the ECJ's rulings. This means that the doctrine operates in the future by following the Spiliada test. Thus, most likely in the future, the doctrine will operate in a way which follows the English law, no longer the EU law or the limitations explained by my teammates. Nevertheless, the limitations might still apply if the UK rejoins the Lugano Convention or the Hague Convention. It is possible that the UK joins both the convention, as there were evidence that the UK has applied to rejoin such convention in April 2020 and December 2018 respectively. Nevertheless, until present, UK has not successfully rejoined both conventions due to EU's constant obstruction. In the absence of such agreements or treaties, the English courts will resort to the English domestic law, which is following the Spiliada test, without any limitation, because Brexit has caused the ECJ's rulings to be inapplicable in the future. That is all for my part. I will now pass on to Zhichen to continue discussing the future development of the doctrine. Thank you.
Thank you, Anchi. Moving on, the court can choose to adapt the English doctrine of forum non-convenience to the American common law model. In the case of Piper Aircraft Co. and Renault, where forum non-convenience became forum, plaintiffs suing major local corporation. The state court adopted Piper to reduce the difference for the forum plaintiff choice of forum. The courts further explained that the doctrine involved flexibility and discretion, and that no specific circumstances will require a court to grant or to dismiss on the ground of forum non-convenience. The court also considered public interest factors such as the judicial efficiency and economy, the application of choice of law rules, and other public policy concerns. The Piper Court determined that public interest factors supported dismissing the case in favor of more convenient forum. Therefore, the more it appears that consideration of convenience favor the conduct of the lawsuits in the United States, the more difficult it will be for the defendant to gain dismissal for forum non-convenience. On the other hand, in the event where the plaintiff's choice of a United States forum was motivated by forum shopping reason, the court also considered the habitual generosity of jurists, the plaintiff, and the defendant's popularity in the region, or the inconvenience and expense to the defendant. The less difference the plaintiff choice command, the easier for the defendant to succeed on the forum non-convenience by showing that the convenience would be better served by litigating in another country court. Nevertheless, it can be said that the approach in Piper is substantially similar to Spiliada's approach, therefore it would not make much difference. There is a better option by applying the case of Iragori, as it provided better guidance concerning in the interest balancing and better account for modern day concerns that both Spiliada and Piper Court did not consider. In this case, the court concluded that the plaintiff's choice of forum deserved little difference. With respect to the availability of an adequate alternative forum, the court began by noting that defendants had expressed their willingness to consent also to the jurisdiction of the Russian court. Also, it must be pointed out that the court must be mindful when considering applying this case, as plaintiffs sometimes choose a forum for forum shopping reason, and the defendant may also move for dismissal on similar reason. The court should therefore arm themselves with an appropriate degree of skepticism in assessing whether the defendant has demonstrated genuine inconvenience and a clear preferability of the forum. This sums up the future development of the doctrine. Thank you. In conclusion, the doctrine of forum non-convenience has been formally accepted by the English court in the case of Aberdeen Beaver and limited by the case of Spiliada. There are also restrictions imposed by the international treaty and also decision. Nevertheless, it is foreseeable that due to Brexit, the limitation imposed by the convention will cease to exist. Also, it is argued that the application of doctrine in irregularity case should be considered by English court to improve the current doctrine. That's all for our presentation. Thank you.